You first, so.
All right, Deputy McLeish, are we ready to go on Mr. Bass?
Yes, sir.
All right, and is all the paperwork signed?
The waiver of rights is not signed by the state. Everything else is signed.
The waiver of rights and, but everything else is signed?
Yes, sir.
All right, so Steve, sign that at some point today.
I'll come by this afternoon, Your Honor.
All right, court call CR 16294, State versus Cullen, Andrew Bass. And Mr. Wood, I believe that at our last setting, which was earlier this week, I think the court was unaware of your representation of Mr. Bass. You have filed an appearance in the case, correct?
That is correct, Your Honor. I apologize for that, but you know, Mr. Bass has hired us. We have. I've been in talks with Mr. Cox for some time now. Obviously, there was a mix-up there earlier this week, but we have worked the case out and are ready to proceed today.
Okay. And what's the terms of the plea agreement?
Your Honor, it's 2 years confinement in TDC. Mr. Bass has credit for 227 days. There are 7 counts in the motion to adjudicate. The state is going to proceed on 6 of those 7. We're going to abandon count 7. And Mr. Bass is also going to be responsible for the remainder of his financial obligations.
Thank you, Mr. Cox.
And that's our understanding of the recommendation, Your Honor.
All right, Mr. Bass, if you will, raise your right hand, sir. I'm going to place you under oath. Mr. Bass, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes.
All right, you may put your hand down. All right, Mr. Bass, you appeared before the court on December 18th of 2018. You pled guilty to the 3rd-degree felony offense of assault of a family or household member with previous conviction. At the hearing, the court found the evidence substantiated your guilt. However, the court deferred the finding of guilt and placed you on community supervision for a period of 4 years and assessed a $1,500 fine. It was during the term of your community supervision that the state filed its amended motion to adjudicate, and I believe that was filed on March 9th of this year. And have you had an opportunity, Mr. Bass, to review that motion with your attorney, Mr. Jeff Wood?
Judge, we're having trouble hearing you.
I'm not having.
Let me make a.
I can relate. He's asking, have you had a chance to read the motion to adjudicate?
Judge Martin, it sounds like the same issue we were having the other day with the volume. I think you said that you adjusted a setting or something. We've got the volume turned up all the way at this end.
Does this make a difference?
Absolutely. Thank you.
Okay. All right. So, Mr. Bass, have you had an opportunity to review that state's amended motion to revoke filed against you?
Yes, sir.
And Mr. Wood, does your client waive the formal reading of the state's amended motion to revoke?
We would, Your Honor.
All right. And Mr. Bass, are you pleased with Mr. Wood's representation of you?
Yes, sir. I am.
Feel like you've had sufficient time to discuss the case with him and have all of your legal questions answered?
Yes, sir.
Now, you kind of shook your head like this, which
Oh,
indicates.
wait, I mean, yes, sir, I do. I mean, we didn't discuss a whole lot, but yeah, I believe we discussed enough. Yes.
All right. And you believe that you're ready to go forward today with the plea agreement that you've reached with the state of Texas?
Yes, sir, I am.
All right. And Mr. Wood, you do believe your client to be competent today?
I do, Your Honor.
All right. Then, Mr. Bass, let me ask you as to count 1, count 2, count 3, count 4, count 5, and count 6, with the state abandoning count 7. How do you plead to counts 1 through 6 as contained in that motion? Are those counts true or not true?
That'd be true, correct? True, yes, sir.
All right, and Mr. Bass, are you telling me that those counts are true because in fact they are true and for no other reason?
Yes, sir.
No one's threatened you, forced you, or made you feel like you've had to plead true to those to those counts. Is that correct?
Yes, sir.
All right, the court will accept Mr. Bass's plea of true to counts 1 through 6 as contained in the state's amended motion to adjudicate and revoke community supervision. Is there anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense?
Nothing further, Your Honor.
All right, court, Mr. Wood, is there any objection to the admission of the defendant's waiver of rights and plea of true at State's Exhibit A?
No objection.
All right, court admits State's Exhibit A and takes judicial notice of Mr. Bass's judicial confession. Mr. Bass, based on the evidence before the court will find that you have in fact violated the terms and conditions of your community supervision. Court will follow the plea agreement in this case. The court hereby adjudicates you of the third-degree felony offense of assault of a family or household member with previous conviction. The court assesses your punishment in accordance with the plea agreement after revoking your community supervision to 2 years confinement in the Texas Department of Criminal Justice, Institutional Division. The court awards you 227 days for the time that you have spent in jail on this cause. And the court orders you to pay the balance of your financial obligations previously imposed in this case. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you go with the bailiff to be fingerprinted, after which you'll be remitted to the custody of the sheriff. Go ahead,
Thank
sir.
you, Your Honor. I believe that's all I have.
Yes, thank you, Mr. Wood. Good to see you. You're excused.
Good to see you, Judge.
All right, this is CR 19-251, State of Texas versus Robert Leroy Young. And I believe that we are set for a docket call today, Mr. Knoll, is that correct?
Judge, actually, we've come to the point where we have a plea agreement on this case.
Okay, and let me get my notepad out here. Mr. Knoll, can you go ahead and give me the terms of the plea agreement?
And Your Honor, specifically, let me just read from the document here. Plea of guilty, punishment assessed at 8 years confinement, TVCJ 1245 TPC F 19-00388, tampering with evidence, and F 19-00389, which is a PCS penalty group 1 less than a gram. Also a forfeiture of the weapon. The only additional thing, Your Honor, that's not contained in this, and I don't have a problem with it being put on the record. My client didn't appear, I don't remember what date, but did not appear on this case, was picked up on a warrant. When I was talking to Mr. Cox about this case, part of the proposal was that the state would not file an FDA, and I believe that's also part of the agreement.
Is that correct, Steve?
It is, Your Honor.
Okay. All right. And so, Mr. Knoll, your client's going to be pleading guilty to the offense as indicted, felon in possession of firearm.
Correct, Your Honor.
And just let me read this back to you so that I'm clear. He's going to plead guilty. The recommendation is 8 years confinement in the Texas Department of Criminal Justice with the, is there a fine?
No fine.
And are there court costs?
Court costs are 290. And then there's indication of reimbursement fees of 105. I'm not exactly sure what that is.
Could that potentially be part of a lab report or lab and PCS, the PCS case that's being 1245s?
Could be, Your Honor.
Well, and it should tell you on page 2 of that judgment.
It does not indicate that. And generally, 105 would not be the usual lab fee regardless, which would usually be 180.
Well, I'm gonna let y'all take a minute to figure out what that reimbursement fee is. I don't have it in front of me, so it's important that Mr. Young know what that is before the court assesses it. It should be contained in that paperwork.
It's not here that I see.
Is there a bill of cost that was provided to Mr. Young?
I don't have a bill of costs, no, Your Honor.
The defendant doesn't have a bill of cost?
We do not.
All right, I'm gonna let you and Mr. Young have a seat while y'all figure that out, and I'm gonna move on to my next case.
Judge, if I could, the only thing that I can think of offhand, because there was a warrant issued for him, that may be a cost that's in there on this case, because there's a warrant issued on this case, but I don't have it specifically in here. When he failed to appear.
That doesn't satisfy my curiosity, and I don't think that's gonna be a specific enough explanation for me or Mr. Young. So go ahead and have a seat, and I guess I'll let you and the state try to figure that out.
Your Honor, real quickly, I just asked Ms. Avni generally what those reimbursement costs are for, and she informed me that it's generally miscellaneous court costs, warrant fees, stuff to that nature, and that Ms. Cassell, Peggy, would better be able to explain to the court what those different fees are for.
Okay, can you have me call Ms. Cassell, because she's not present in court?
I can give her a call, sure.
Okay. All right, are we ready? Is Mr. Manning available and ready on the writ on Mr. Cooper?
Present ready, Judge.
Okay, is Mr. Cooper available?
Yes, Judge, he's right here.
All right, Mr. Cooper, if you will, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, you put your hand down. You ready to go, Mr. Manning?
I am, Judge.
You may proceed.
Thank you, Judge. Mr. Cooper, I was appointed to your case on July 10th of this year. Is that correct? Okay. And besides the confusion of whether you were Johnny Jude Cooper or another Johnny Cooper, I've been following up on your case and working on that. Is that correct? Yes. To the best of your knowledge. And at this time, I've told you that there isn't a case that's been filed against you. Is that correct? Yes, sir. Okay. And there's not been a case report turned into the DA's office at this point. Is that your understanding? Okay. And when we met on the 10th, you asked if you could get a bond reduction. Is that correct? Okay. And your bond was set at what? Okay. And what?
And Mr. Manning, he's going to have to speak up. I can't hear him.
Okay.
100,000.
Were you able to hear that, Judge?
Yes.
Okay. Mr. Cooper, where do you work?
I'm self-employed.
Okay. And how long have you been self-employed?
For the last couple of years, I normally work with my dad.
Okay. How long did you work with your dad?
Ever since I was 16.
Okay. And if you can just speak up, make sure that you hear it. Do you have family here in this community?
My mom lives in Fort Worth.
Okay. And if you were to be given a bond that you can make or have a PR bond, where would you be living?
I'm fixing, when I get out of here, I'm going to rehab, so it will probably be in Oklahoma.
Okay. And who lives in Oklahoma?
Mr. Manning, can you have him repeat that? I can hear you fine, but I can't hardly hear him at all. Thank you.
Where do we cut out?
You said, where will you be living? And I think I heard him say Oklahoma, but I'm not sure.
Okay. So you'll be going to rehab, is that correct?
Yes.
Okay. And most likely that will be in Oklahoma because of why?
That's where my dad lives, is in Oklahoma. So that's where I'll be going to rehab it.
Do you have any vehicle?
No,
Okay. Do you have a bank account?
no,
Okay. Do you have any other assets?
no.
Okay. Do you have any prior felonies?
I think, but I never was convicted.
Okay.
I'm not sure. I can't really remember.
And have you ever had any difficulty being on bond in the past? Any
No.
bail jumping or anything of that sort? Okay. Do you have a drug counselor who's helping you actively pursue getting into a drug rehab?
Yes, I do.
And what's her name? Okay.
And Mr. Manning, I'm sorry, I can't hear what he is saying.
Well, I can't.
I don't know if he's being soft-spoken or what. I hear you just fine, but I didn't even hear his response to who the drug counselor was.
Miss Cherie,
Thank you.
Judge, at this time, I pass the witness.
State.
Thank you, Your Honor. Mr. Cooper, do you know how many days you've been in the Van Zant County Jail?
a little, I think a few days over a month, maybe a month and 5 or 6 days.
Okay, so if I said 37 days, that would sound right to you?
Yes, ma'am.
And do you know what you're currently being held on, what charges?
I know the charge, but I can't say it. It's, what's it called? Exportation of the elderly, I think.
Okay.
Yeah.
And your current bond is set at $100,000?
Yes, ma'am.
What attempts have you made to contact bondsmen to see if you can make that bond?
My counselor and my dad has made some calls to the bondsman, but I can't come up with that kind of money.
Okay. And if you were granted a bond reduction by the court, you said you would be going to Oklahoma, is that correct?
Yes, to get into a rehab.
Okay. But you don't have any vehicle, is that correct?
No.
So how would you come back and make your appearances for court?
My drug counselor, which is a good friend of mine, and my parents will make sure I get here.
Okay. Mr. Cooper, have you ever been accused of something like this charge before?
Yes, ma'am.
Okay, and where was that at?
In Fort Smith?
Is that in Arkansas?
Yes.
Okay. And have you ever been accused anywhere else of this similar type of charge?
Objection, Your Honor, relevance.
Overruled.
Mr.
You can answer the question, Mr. Cooper.
What was the question again?
The question was, have you ever been accused of this similar type crime anywhere else?
Judge, if we have just a minute.
You may.
No, ma'am.
Your Honor, I'd pass the witness.
Mr. Manning, any additional questions?
None from the defense.
Any evidence from the state?
Yes, Your Honor. The state had tendered via email to you and Mr. Manning proposed exhibit. At this time, we would offer State's Exhibit 1, which is a newspaper article from Fort Smith, Arkansas, on that charge that Mr. Cooper testified to.
Any objections, Mr. Manning?
Yes, Judge, we would object to hearsay and hearsay within hearsay.
Any response, Ms. Heisel?
Yes, Your Honor, that the hearsay rule does not apply during bond reduction hearings.
All right, court's going to overrule the objection and do you have that marked, Ms. Heisel?
Your Honor, I don't believe I do because we were all going to be in different locations. I just sent it via email, but I can come up and get you a State's Exhibit sticker after this hearing.
Well, we can mark it. I just want to know how you want it marked.
Just State's Exhibit 1 if it pleases the court.
All right, court hereby admits State's Exhibit 1 into evidence for purposes of this hearing only. Anything further from the state?
No, Your Honor, State would rest.
Mr. Manning, would you like argument?
Judge, you've heard the testimony today. You heard that Mr. Cooper is seeking drug treatment through his family and his drug counselor from Arkansas. He's seeking to go back to a stable environment there in Oklahoma with his father. You've heard that he doesn't have assets and he has no money with which he can post a reasonable bond, and has no ability to make that bond based on his conversations with his counselor and family, reaching out to multiple bondsmen here in the area.
Thank you, Mr. Manning. Ms. Heisel?
Thank you, Your Honor. Your Honor, you've heard that Mr. Cooper has only been in the Van Zandt County Jail for 37 days on this felony charge. Mr. Cooper is self-employed, and there really was no testimony about his ability to provide for a bond or what amount of bond he would be able to make. The only testimony offered was basically that he has no vehicle, no consistent job opportunity, that he would be returning to Oklahoma, and that his other contact is in Fort Smith, Arkansas, where that's his drug counselor. He has significant contacts in other states because of his history doing the same type of offense in adjoining states. We believe that he's a flight risk, and we would ask you to hold the bond at $100,000 at this time.
Thank you, Ms. Heisel. All right, then based on the evidence before the court is going to deny Mr. Cooper's request for a reduced bond. In this case, the court's going to find that $100,000 at this time is not oppressive or excessive. The court will reconsider that if Mr. Cooper is not indicted in accordance with the law by the 90th day. So, court hereby denies the writ of habeas corpus request and maintains bond at $100,000.
Yes, Judge.
Thank you, Mr. Cooper.
Maybe we can excuse at this time?
Yes, thank you, Mr. Manning.
Thank you.
All right, Mr. Cox, Ms. Cassell brought me the bill of costs, and on Mr. Knoll's case, and it just says local consolidated court costs of $105. But there's also a state consolidated court cost of $185. Time payment fees, peace officer fees. It shows on here $445 is what the bill of costs say. I don't know if that's reflected on the judgment there or not, but.
Judge, Mr. Knoll has the judgment right now.
Would you like me to go get Mr. Knoll, Judge Martin?
Yes, I believe he's the only one left. Is that right?
Yes, sir.
Yeah, you can tell him he can come on back in.
Okay, thank you.
Yes, sir.
Mr. Knoll? Judge will give you the answer to that question.
All right, we're back on the record in CR 19-251, State versus Robert Leroy Young. Mr. Knoll, I just informed Mr. Cox that the clerk's office brought me a copy of the bill of costs, and it shows a grand total of $445. Do you see that anywhere within the judgment? I show local consolidated court costs of $105. State consolidated court costs of $185. I believe that should be our $290. I believe you said that earlier, correct?
I did say 290, but that was just under court costs.
Right. So that's under court costs. And then I show under reimbursement fees that there was a time payment fee of $15. Then there's a peace officer fee that is relating to a capias of $100.
And that's the one,
Hang on, hang on just one second. Then there's a peace officer fee of commitment or release from jail of $20. And another peace officer fee of take and approve bond, $20. The total reimbursement fees being 100 and looks like $155. Is that what you show?
There's, under reimbursement fees, it shows 105, and maybe that's just a typo, I guess, as opposed to 155, it says 105.
Yeah, I'm
Sounds
gonna
like
show,
one of the $50 fees are missing.
yeah, I'm gonna show you where it says, this right here says reimbursement fees, and then there's the totals.
155. And it looks like the total there actually says 145, but it is 155 if you add up 100, 20, 20, and 15 is 155.
Yes, sir. That's what I'm wondering. State, do you want to consult with Ms. Abney to find out what the reimbursement fees? Because the clerk's office is showing a different amount than what's on the judgment.
Yes, sir. I'll check with Ms. Abney.
Okay. All right, we'll stand in recess and give her a chance to do that, and then let me know.
Thank you, Judge.
Sir, if you want, you can just have a seat right there. This one all.
I'm not gonna die.
All right, Mr. Cox, were you able to consult with Ms. Abney?
I was, Judge, and Ms. Abney informed me, and again, I don't have a copy of the judgment in front of me. Mr. Knoll will have to tell us if our math is correct, but the reimbursement charges of 105 and the court costs should add up to that grand total of 445 that's on the document that Peggy provided to the court.
Yeah. The court costs are 290. And then this is what shows up under the reimbursement fees: 100 plus 20 plus 20 plus 15 be 155. The 155 plus the 290 would be 445. So it wouldn't be 105. It's about $50 off.
Okay, do we need to amend that, or can we just have Mr. Knoll write it on the judgment?
Judge, I'm happy to just write it in, cross out the 105, write in 150, I'll initial, and my client can initial.
155.
Thank you, Judge.
Yeah, and you don't need to initial the judgment, Mr. Knoll.
Okay, we'll just write in 155.
Yes, sir. And just so that Mr. Young is aware. All right, so we're back on the record, CR 19251. And so I was repeating back what I heard the plea agreement to be: 8 years TDC, 1245 F1900388, which is a tampering with evidence, 3rd-degree felony. 1245 F1900389, possession of controlled substance, penalty group 1, less than 1 gram. And forfeiture of the weapon. And what is the weapon specifically, Mr. Knoll?
Since it was a firearm,
Look on the second page of the judgment, and it should be spelled out there.
the Glock 30,
A Glock 30.
45 caliber,
Does it have what caliber?
45.
And does it have a serial number?
I might have to read the fine numbers if I have a serial number.
It would be on the second page of the judgment, most likely. The second or third page, right above my signature.
Actually, I don't think it appears there. It doesn't. I've got, I'm trying to see on the offense report.
Judge, I've got the serial number here.
Well, it sounds like none of that information made it to the judgment. And I think the law enforcement agency is probably going to want that in the judgment so they have an order. Do you see it on the judgment, Mr. Knoll?
No, Judge, the only reference to the weapon in the judgment itself is just says weapon forfeiture. But there's no serial number. Not in the judgment.
Mr. Cox, do you want to have Ms. Abney revise the judgment and take it out to the sheriff's office so that we can include the weapon identification so that the agencies can rely on it without having to seek a subsequent order?
Yes, sir, we can do that.
And then we'll just go ahead and have her change the reimbursement fees to 155 as well.
The serial number is WAN 292. Right there. Oh, by the X.
There it is. Oh, Judge, it is here. It's just fine print. It does appear at the very top, second sentence, it indicates Glock 30 SN number WAN 219. So,
W as in Wanda, A as in Apple, N as in Nancy, 219?
yes, Your Honor.
Okay, and that is on the judgment, correct?
It is.
It is. Okay, good. All right, that's what I needed to ensure. Okay, good. All right, so Mr. Young, if you will, raise your right hand. Have I placed you under oath yet, sir? Nope, I don't believe I have. Mr. Young, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
All right, you may put your hand down. All right, you are in fact Robert Leroy Young, is that correct?
Yes, sir.
And Mr. Young, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Kurt Knoll. Do you feel like you've had sufficient time to review your case with Mr. Knoll, have all of your legal questions answered?
Yes, sir.
Are you pleased with his representation of you?
Yes, sir.
Is there anything that you don't understand that you have reviewed and signed?
No, sir.
And you're swearing to me that your signature, as it appears in that plea agreement, is in fact your signature, and you sign that stating that you understand everything that you've read and signed.
Yes, sir.
All right, Mr. Knoll, do you believe your client to be competent?
I do, Your Honor.
And you explained to him his legal and constitutional rights?
I did, Your Honor.
All right, Mr. Young, you are indicted with the third-degree felony offense of felon in possession of a firearm. That carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries a fine not to exceed $10,000. Any kind of sentence or plea agreement negotiated between you and the state must fit within that range of punishment. Do you understand that?
Yes, sir.
And based on what Mr. Knoll told me about the plea agreement would fall within that legal range of punishment. So let me ask you at this time then, Mr. Young, how do you plead to the third-degree felony offense of a felon in possession of firearm alleged to have occurred on June 25th, 2019?
Guilty.
And Mr. Young, are you pleading guilty because in fact you are guilty of that offense?
Yes, sir.
Has anyone threatened you, forced you, or made you plead guilty to this offense?
No, sir.
All right, court will accept Mr. Young's plea of guilt at this time. Mr. Knoll, is there any objection to the admission of State's Exhibit 1, the stipulation of evidence?
No, Your Honor.
All right, court admits State's Exhibit 1, stipulation of evidence, takes judicial notice of Mr. Young's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
Anything further from the defense?
No, Your Honor, also resting closed.
And Mr. Cox, if you can give me a brief summation of the facts, please.
Yes, sir. This was a traffic stop. Wills Point police officers recognized the defendant. They knew that he did not have a valid driver's license. They also knew that he had 3 active warrants out for his arrest. So they initiated a traffic stop. During the traffic stop, the officer asked the defendant if there was anything in the car that he shouldn't have. He responded there was a gun under his seat, and sure enough, there was a gun under his seat. He's a convicted felon. He was arrested. He was taken to the Grand Saline Police Department while they were doing his book-in paperwork. He abandoned a baggie of methamphetamine, which led to the tampering and the PCS charges that the court is taking into consideration today when the court sentences Mr. Young.
Thank you, Mr. Cox. Mr. Knoll, any objection to that summation?
That sounds pretty accurate, Your Honor.
Okay, then based on the evidence before the court will follow the plea agreement in this case. Court hereby finds that the evidence substantiates the guilt of Mr. Young. The court convicts Mr. Young of the third-degree felony offense of felon in possession of firearm. Court assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice. Court assesses a 0 fine, $290 court cost, $155 reimbursement fees. Court forfeits the weapon seized in this matter, namely a Glock 30 .45 caliber, serial number WAN219, and the court dismisses under section 1245 of the Texas Penal Code unindicted cause numbers F19-388, a tampering with evidence, and also F19-00389, possession of controlled substance in penalty group 1, less than 1 gram. Mr. Young, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir.
Thank you.
Thank you, Judge. May I be excused?
Yes, Mr. Knoll, we missed you this morning on one of your clients, Miss Amy Davis. I'm sorry, Dawn Lee Davis. Dawn Lee Davis. The good news for you is that she did not appear for arraignment. The bad news for her is that she did not appear for arraignment. So the
To be candid with the court, I'm not sure that I had it on my calendar, but I also had a revocation hearing on someone that had been examined by a psychiatrist, declared competent, and we had some competency issues during the hearing this morning. I'll see if I can get a hold of Miss Davis I don't believe I've ever heard from her, but I'll attempt to locate her.
Yeah, she's on a personal bond, so the court at this time has already found her bond to be insufficient.
Okay, Your Honor.
So once we get her back in custody, if you can get her in custody, then we can get her set.
Thank you, Judge.
Thank you, Mr. Knoll.
May the state be excused as well, Your Honor.
Let's go ahead and address Mr. Kentrell Turner, CR 19209.
Oh, yes.
Mr. Scott is on vacation, and my staff has confirmed that Mr. Kentrell Turner is still in the U.S. Marshal's custody in Louisiana. And the information we have says that there's no court docket setting yet on the federal charge. So just for calendaring purposes, we're going to go ahead and set Mr. Turner for status of his custody. And I'm going to set this out a little bit. I'm going to set this in October. We'll set this October 13th. And Mr. Cox, do you know, does the state intend to proceed with the prosecution in this case?
At this point, we do.
Okay. All right. So we'll revisit this on October 13th and see if we have Mr. Turner in our custody.
Yes, sir.
All right. Thank you. Appreciate it.
Yes, sir. Thanks.
You have a good day.
You too.